All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. I'm excited to have you join us here today for avoiding high payments and increasing default rates experienced by student loan borrowers. Before I introduce our speaker, I do want to go through some quick housekeeping announcements. This training is being recorded, so if you registered for the webinar, you're going to receive an email from Zoom within 24 hours or so. That email is going to include a link to the recording, a link to the materials, and some additional information as well as the CLE code. The training was approved by the Florida Bar for one general CLE and one business litigation certification credit. I'll announce the CLE code towards the end of the presentation. I'll drop it into the chat, and it will also be included in the email that goes out from Zoom. So closed captions are enabled for anybody who needs them. If you're having any issues with accessibility or the captions, you can reach out to me directly. The training is being co-hosted by the Public Interest Law section of the Florida Bar or PILS. If you're not familiar with PILS, I will drop the link for the PILS website into the chat. It will also be included in the information that goes out via email, so you can check out all the work groups and all the advantages of joining PILS. And final piece of housekeeping announcements are questions and answers. We have the chat, we have the Q&A feature towards the end. You could also raise your hand if you want to come off mute if it makes it easier for you. But yeah, we'll be monitoring your questions as they come in. If we're running a little bit late with the webinar, I may ask you to hold off on questions towards the end, but we'll try to address questions as they come in. So without further ado, I want to go ahead and introduce our amazing speaker today, Christie Arkovich, a Florida attorney for over 25 years, graduated with honors from Stetson College of Law in '92. After working in commercial litigation, she established her own practice in 1995. Dedicated to staying at the forefront of legal developments, she has trained with top consumer rights experts and attended specialized programs on bankruptcy and student loans. An active member of multiple legal associations, Christie frequently speaks at CLE seminars and authors the Student Loan Sidebar column for the Tampa Bay Bankruptcy Bar Association. A former trial counsel for student loan servicers, she now focuses on consumer advocacy. So without further ado, I'm pleased to pass it over to Christie. Christie, the floor is yours.
Thank you so much. I really appreciate it. So we decided to set this up with PILS because we see things slipping back a little bit with student loans. In other words, the common belief back in the day was that bankruptcy couldn't help student loans. There's really nothing that could be done with student loans, inside bankruptcy, outside bankruptcy. And that had changed significantly, and it still remains true, although it is very different now. And so we're going to cover some of those differences. But what I'd like to do is, if you have any questions while we're talking, go ahead and just put them in the chat. And if it's relevant to what we're talking about right then, we can go ahead and answer those. So what you're going to see now is people that have been on a safe forbearance for a while. They've not made any payments. They're very concerned about what they're seeing out there, what they're reading out there, and they're starting to get payment notifications. Interest is accruing. And so it's starting to press on them. We've had a few years now where student loans have not been in the forefront due to all the COVID relief, the Americans Rescue Act with tax relief. You had a lot of pauses. You had a lot of retroactive, programs are still working. It was just really, really very messy, but also not top of mind for a lot of folks. The pause, though, has ended. Negative credit reporting, so forth. Higher payment notices are going out. And we're starting now to see high default rates potentially coming out. So one thing I want to mention is, first off, with student loans, things change a lot. I've done a few different areas of law, and I must say that with student loans, we've had so many changes in the past couple of years, or I'd say maybe 4 or 5 years. It's been kind of insane trying to keep track of everything. So we have a YouTube channel. I also have a blog. I've got some blogs coming out and have recently here in the last month or so. I've been traveling, so I haven't done too much in the YouTube channel, but next few months here in Florida, we'll be getting more up. And we also have some answers now. We did not have answers for a while, and so it was really hard to do a lot of YouTubing when I didn't really know what to say. So to keep on top of things, I do have some resources at the end of this. And then also, you're always welcome to take a look at our blog, or we have a sidebar, a crammed down column. It's not actually a column. It's more like a couple pages because there's always so much to talk about with student loans. But we put that out in a quarterly publication with our bankruptcy judges, bankruptcy practitioners on either side and so forth here in the Middle District of Florida. And that's something that we always put on the front of our website as well, the latest edition for that. So there is a lot of materials to try to keep yourself up to date. I would not necessarily just get the news from clickbait type thing, the headlines, because often, they're not actually right, or they focus on one tiny little element of something. And we are very strong advocates for our clients. We try to tell someone, here's what you need to do and what kind of loans that you have and why you need to do it. So I mentioned previously about this default cliff. Now, I don't really want to portray this as something that is imminent, but in actuality, it kind of is. We still have a lot of folks out there with student loan debt. It's kind of considerable debt. It's basically a mortgage payment, and we're starting to see late payments climb. We've had a lot of people that were counting on SAVE, and SAVE has been under an injunction. That's one of our income-driven plans. It was basically a plan designed to lower folks' payments and not have interest continue to accrue on a payment plan. So there were some elements to it that were in place, and then there were some elements that we expected to have happen. So it was basically a 10% plan, where in other words, you paid 10% of your earnings. There was an offset for expenses using the poverty level and things. And then it was even going to go to 5%. In other words, you're making 5% of your income as a payment to student loan minus expenses and things, and how that was calculated. And that was supposed to go into effect for undergrad loans last summer. But last summer, well, when I say last summer, I actually mean a while ago now, we had this SAVE injunction. And it was basically, 2 summers ago, I should say. And so what they did was they just put everybody on forbearance. And so you've got a situation where people have not been making student loan payments of any kind. They haven't been certifying their income, whether it's gone up or down. And if they're calling their servicers, many times their servicers have changed. During the COVID time, we've had a lot of servicer changes. The Ombudsman office, for most part, has kind of been closed down. We don't really see that as an avenue of relief any longer. What the Ombudsman was sort of an appeal department within the Department of Ed. If we had questions about things, we could go to them. They handled unique situations. And what we really liked about them was that we would generally get our question restated. We would get an answer back and supporting documentation, and it was in writing. We don't get that from a servicer. I tell my clients, hey, if you call your servicer now, if you call them 3 or 4 times, you will get 3 or 4 different answers. And it's very confusing for them to understand, well, maybe one of the answers is right, but which one is it? And it's a problem. So we like the Ombudsman office for that. Maybe one day we'll have a different type of office that's similar to that, but maybe run under something other than the Department of Ed. We don't really know. But what we see right now is these high payment notices going out. We see a very big backlog of unprocessed applications for income-driven plans. We hope that the Department of Ed will commit additional resources to clear that backlog. We do see seriously delinquent increasing, and we see new serious delinquents. Now that number, that 12.88% that I have here, new seriously delinquent, those are folks who hadn't previously been delinquent. And so they may not be familiar with, there's no point in defaulting on a federal student loan. Basically, there's no statute of limitations. They don't settle. And so all it does is hurt your credit and allow for potentially income seizure through garnishment or tax return seizure or offset of Social Security. There's really nothing to be gained. It seriously hurts someone's credit. Whereas with private loans, we often will encourage default. Maybe not encourage it, but we won't be opposed to it, because that's where we can negotiate very reasonable payment plans. We're seeing significant hits to credit because no one has one student loan. They have, 3, 4, 5, 6, 10 loans. And so you'll have 10 dings on your credit each and every month of delinquency. And so that's starting to roll into other areas of their life, to where delinquent student loan will eventually impact the ability to get housing, for instance, whether you're renting or owning. And additionally, once you default, which they do have a very lax policy with regard to how long it takes to default. Unlike a private student loan, you don't default right away. There's 270 days, which is basically 9 months that someone can be delinquent. In other words, they're behind in payments before they actually become in default. And at that point, that's when you have different things that kick in. Collection avenues, you have reports to CAVR, which is the mortgage underwriting, the database, I guess, that mortgage underwriters use, whatever it's called. And you also have a 25% attached to the loan for someone who's in default. So the Department of Ed and all of its federal servicers, they don't keep track of actually what is done in collections. So in other words, if there's 10 letters or 100 letters, if there's 10 phone calls or 100 phone calls or whatever it is, they don't keep track. They just add 25% to the balance. And we've seen multiple defaults, which obviously creates an enormous balance. So there's really no point in defaulting, and that's something that we want to try to avoid. So if all else, for you as a takeaway for this seminar, I'd like you to know that all is, is not for naught. There's avenues out there to take. Try to keep your clients out of default. Try to get them on the IDR that maybe makes the most sense for them, and then try to be cognizant of tax relief in the future and so forth. We're going to split this up. The first half, we're not really talking about bankruptcy, and the second half, we'll be talking a little bit more about some bankruptcy options, because it's looking more and more every day that the bankruptcy options may in fact turn out to be much better than non-bankruptcy options. So they started involuntary collections May 5. One of the nice things is we expected Social Security offsets this summer. We didn't see them. And the Trump administration has come out and said, hey, we're not going to offset Social Security for this. We don't know when and if that may change. Of course, that is a collection avenue available for the Department of Ed and all of its servicers, and they can offset Social Security, but at the moment they're not. But they can do collection calls, negative credit reporting. Wage garnishment is fairly simple. A good thing is to make sure that your clients understand that it's good for the Department of Ed to have their latest address, because the only way they're going to know what's going on is if they go on to studentaid.gov, which is a government online site, or open their mail with the current address on file with the Department of Ed. Otherwise, it's going to truck along and they're not going to know what's going on. And what that means is that for garnishment, for instance, all they need to do, the Department of Ed, is send a letter. And the letter may go to a prior address. If it does, that borrower may never have notice ahead of time. There's no court hearing or anything like that. After the fact, they can ask for a court hearing for hardship exemption, but before that, they cannot. And we're hearing mixed reports on how the hardship garnishment hearings are going. Typically, we did not see a lot of exemptions, unlike state court, and so I wouldn't count on that. They can garnish 15% of someone's wages without really much notice if they don't have a current address. So we encourage folks to keep their address current. There's tax refund intercepts. We are seeing those. Basically, you have the injured spouse. They can file to get that waived if they need to. Currently, there's very little oversight of debt collectors. We did have a lot of oversight with the CFPB. There was also some internal agencies like the Ombudsman and some other things that would work on that. But right now, we don't really see a lot of that. So we're using FCRA, FDCPA. We're using a lot of the consumer actions more frequently, and we anticipate that that will just increase. There has been a lot of confusion with delay, and different answers by the servicers. We hope that'll eventually go away. The Department of Ed is not really meant to be the largest bank in the United States. And so we don't know exactly what's going to happen and who's going to be responsible for some of the communications out there. But we hope that eventually that's going to settle down a little bit. Right now it's messy. There's a lot of folks who just can't get answers on what to do with their student loans. And they're worried because interest started to accrue again on August 1st. During the SAVE forbearance, folks were not being charged interest. But starting August 1st, interest has started to accrue again. So they're getting notices that says, hey, your loan balance is going to increase, or here it is now. So what are your clients out there reading? Well, they're reading about this executive order where they're disbanding the Department of Ed. They're reading about the head of the Department of Ed anticipates that she's going to work herself out of a job eventually. They're just worried about everything. And so what we focused on was, well, there are certain things that are laws, and there are certain things that are guidance or just something that we want to do. So the Higher Education Act, it's a law. Income-based repayment, a law. Public service loan forgiveness, a law. Those things are not going away, at least not easily. And so we've been focused on, if it's a law, it's probably going to survive. If it's not, maybe it won't. It all kind of depends. There is one avenue with bankruptcy that we think will survive, even though It's technically not the law, and I'm going to get into that in the second half here. So first of all, anyone who's already been forgiven, we don't think there's going to be any change there. We don't think there's going to be any reach back. There's a lot of issues about whether or not someone can reach back like that. So if you've had some prior forgiveness, that person's probably okay. If anyone's been on a safe forbearance, they may as well get off. There's really no point. I mean, you can continue to stay on a safe forbearance if you want right now. You're not getting credit towards anything, not public service, not income-driven plan, but you are not making a payment, and your credit is not impaired if you're legally in this safe forbearance. But we've encouraged folks to go ahead and get out of that. Think about getting an IBR or pay, or getting in line for RAP, maybe doing a disability discharge, thinking ahead, basically. SAVE is likely to end. We expect to receive notice any day, really. And when we do, those folks are going to have to do something. And so what will exist? Well, we do have some answers on that, and I have some slides going to talk a little bit about that. Currently, in the last few months, we've been telling folks income-based repayment. It's a law. It was basically passed in 2009. It's a 25-year repayment term. Someone can file a separate tax return and have their payment based solely on their income. IBR is looking pretty good. And then RAP came about. RAP was a result of the Big Beautiful Bill, BBB, that will start July 1st of 2026, so next summer. And it's going to be a 30-year plan. That does not sound good. 30 years is higher than any of the other years, 10, 20, or 25. But in reality, it's not that bad, because in many cases, the payment is actually going to be lower. It's simple, which is kind of good. There's not as much flexibility, but it is simple. And for servicers who may or may not understand and communicate this, simple is good. And RAP also has an interest subsidy similar to SAVE. So in other words, if someone cannot pay their interest that month, that interest is waived. So there are advantages to RAP. And I'm going to go through what some payment comparisons are here in just a couple minutes. The IDR counter, I'm going to go through that a little bit more in detail. That's the biggest thing out there right now, is how much time does someone have towards forgiveness? Do they have a few years left? Do they have 1 year left? Or are they already entitled to it? And then borrower defense to repayment, that involves someone who went to a school that we alleged was fraudulent in some fashion in what they were telling that student. And so that's a program that's been around for a while. It's undergone a number of changes. It will continue to change. I won't get into that too much here today, other than the rulemaking that's going on will give us a few more answers. By July 1st, we anticipate for that to be rolled out. And we'll know, right now there's a class action settlement that's out there. If you are in the class, those people might have already received discharges, or they are pending. If you're outside the class, I wouldn't expect relief. It is a way for you to have forbearance for a short time, but we don't anticipate it really going anywhere, and I certainly wouldn't count on it. That being said, there's nothing wrong with filing a borrower defense application, having it pending while you also do income-driven repayment, and then just seeing what happens with borrower defense. And then for expectations, we don't think ED is going to be disbanded. We do think it's going to be smaller than what it ever was. Many of its functions may be moved to other agencies, even to states. In many cases, recertification of income has moved to 2026. What that means is that someone who has had an income-driven plan, they have to certify their income every year, right? And make a payment based on that new income. That's been postponed, that certification. Now, when you certify your income, you can do so by sending in a tax return. You can have it automatically linked if you wish. You can also send in a pay stub or two, or there's other mechanisms too. It's called alternative documentation, maybe a profit and loss statement if you have your own business. And the importance to know is that if you recertify your income earlier, like if you consolidate your loans and you submit your new income with that, it's going to have a payment based on that new income now, where maybe your past payment was based on an income that was 4 years ago and you haven't had to recertify all this time. The other things that are important is you can always ask for your payment to be recalculated. So let's say you have a client, they're trucking along on a $1,000 payment, all of a sudden they lose their job. So they can ask for their payment to be recalculated based on now zero. And for the remainder of that calendar year, whatever their 12-month start time is, like February to February or so, for the remainder of that year, they can be based on zero, even if they get a job the following week. They're not required to recertify again until their recertification date comes up. And so a lot of folks don't realize that. They don't do the recalculation. What they do is they go on forbearance. They go on an economic forbearance or deferment or something like that. Well, in the past, what that's done is it's basically added additional interest because the loan is capitalized at that point. It's moved off into forbearance, and then they don't get credit towards income driven. So why not stay in the income driven plan, receive credit towards it, and have your payment lowered, and maybe even lowered past the time of unemployment or lower income or something, just because it continues to the next recertification date. So remember that word, recalculation. How do you get it? The application, when you're asking for income-driven plans, one of the first questions is, are you asking to recalculate your plan payment, or are you asking to move to a different plan? So it's right in there. Interest restarted August 2025. That's kind of a big deal. We were not seeing the accrual of interest before. The folks that we receive inquiries from, our law office is in Tampa Bay. The folks that we receive inquiries from are typically those that they've gone to school for quite some time. Maybe they've switched degrees, and maybe they went to out-of-state colleges. They have a huge amount of loans, and maybe it's been a long time that they've been in forbearance or deferment for such a long time that the balance has increased. So the interest to them is an enormous amount of money. And so we do everything we can to make sure that they do not have a tax bomb at the end of their income-driven plan, or figure out a way to deal with it. Parent Plus consolidation, that's really been cleaned up. What that means is that a lot of times you may have someone that has a Parent Plus loan. In other words, the student, what they could borrow was not sufficient to cover all the expenses of that person going to school. And so that Parent Plus loan often is the same size as a student's loan. It's very large. It's not a small thing. And a Parent Plus loan, they're not really looking at someone's runway of income in front of them to repay that loan. But the interest is fairly high. It's 8 to 8.5, maybe even a little bit more. And there's no assets necessarily, or no income to generate a payment there. So a lot of them are delinquent or in default, and the payments are very, very high for those loans. We've often seen some Parent Plus payment plans in the thousands. Traditionally, what someone would have to do is they'd have to consolidate their loan one time to be eligible for what's called the income contingent repayment, ICR. A little bit higher of a payment, 20% of someone's income instead of the 5 or 10 that we might have seen under SAVE. And there was this loophole called a double consolidation. I won't get into the specifics, but if you did it correctly, there was a way for you to basically get rid of the stigma of having a Parent Plus loan and be eligible for some of the other repayment programs that were lesser of a payment than ICR, like SAVE. We no longer have to do that, but you do have to consolidate at least once. So it's very important. This is probably the largest thing out there. Very important that someone, if they have a Parent Plus loan, they need to consolidate by July 1. And that's not just submitting an application to consolidate. It actually has to be funded and completed by then. So I would encourage folks to start, say, in March or even earlier. And they do one consolidation. They don't have to do two. They don't have to do it in a special way, just one consolidation. What that will do is it will enable them to participate in an income-driven payment plan in the future. If they don't do that, they will not. And they will just be told, here's your standard payment. It's several $1,000s, and it doesn't matter how much you make. It doesn't matter how old you are. Now, maybe someone's entitled to a bankruptcy relief or disability relief or something else, but they would not be eligible for an income-driven plan. Now, the bankruptcy process that I mentioned that we do expect is not a law. It allows for an attestation through an adversarial process. I'll cover that a little bit further here in the second half. The process was started during the first administration of President Trump. It's not a law, so a lot of times we expect those things to go away, but I don't think this one's going to go away. There's guardrails in place. The bankruptcy courts are in charge of monitoring those programs, and I think it's going to survive, and it's restarted already. And we've seen some really good results, and I'll go through that here in a little bit. There's also something called a bankruptcy IDR that is on pause. I have high hopes for this program, but I don't know. What it was is it's all been in place. So all the regs and things are laid out, the rulemaking and so forth. But it was under the SAVE injunction. So it stalled the summer of 2023. What it was going to do was enable someone who files bankruptcy to have their plan payment satisfy an income-driven payment. That could be really, really nice for someone who has a lot of expenses that wouldn't be covered with a traditional income-driven plan. So in other words, when you have a traditional income plan, It doesn't matter if you have high childcare costs. It doesn't matter if you have high medical costs, maybe a large mortgage. None of that matters. They're looking at a strict percentage of income. With bankruptcy, we're looking at their overall, their life basically. We're looking at disposable monthly income. We look at everything. And if someone has, I mean, we can even send someone to Walgreens or whatever and get a 12-month prescription list on what they have for out of pockets. All that is taken into account. Well, with the bankruptcy IDR, then you can have a much lower payment than you would be able to have outside of bankruptcy. And it still allows you to get income-driven payment plans. So we anticipate that if that does go into effect, if the pause comes off for that, and that's part of the SAVE litigation, that maybe we'll see this IDR available in bankruptcy. So I've mentioned SAVE quite a bit. I won't talk a lot about it here, but basically it's what a lot of folks have been on the last few years. It was to allow low payment. It was increasing the expenses that were allowed to be subtracted before that payment was calculated. It would exclude the spouse's income. You'd have a full 100% interest subsidy. It was going to allow forgiveness of smaller loan balances. And it was all stayed basically summer of 2023. So now we have people on SAVE forbearance, but I do believe that in most cases it's time to move on to other plans. We're not, that is probably going to go away. There's almost 100% certainty about that right now. We are seeing a lot about the IDR audit. There used to be on the right-hand side, we have the 13 years, 1 month. That kind of notification was available on someone's studentaid.gov government site. That's gone now. There is a back door to that. I have the tab there at the bottom that says where you can go. I tried it last night when I was preparing the slides. And it showed that I was unauthorized. So I had the other attorney at our office try it as well. And she ended up getting gibberish. So I'm not 100% sure that this back door to figure out how much time someone has left is available. It was available, but we tested it as of last night and it didn't appear to be working. Maybe that was just a fluke. What that was is a one-time fix to allow folks to get credit for forbearances and deferments when they were over 12 months. We used it an awful lot, and we can combine it with public service. People with joint spousal consolidations that were separating loans, they were eligible for it. It's something that automatically happened. Someone just needed to have a direct loan by June 30, 2024 in order to get it done, but it hasn't been finalized yet. We've had a lot of people who have reached forgiveness through that program, and it's still ongoing. We have heard it's still there, but the calculations are hard to find because if you ask your servicer how much time you have left, a lot of times that servicer is not going to be able to answer. I mentioned
Actually, there
before.
was one, sorry to interrupt, there was one question related to public service loan forgiveness and SAVE, since you had the SAVE slides a few
Okay.
slides back. I
Okay.
believe you already addressed it, but wanted to make sure it was addressed again just in case. And the question is, if currently on the SAVE program and making monthly payments in the program, do these payments do not count for forgiveness?
Well, under SAVE, you cannot make monthly payments right now. You're not getting basically forgiveness credit under a SAVE. You would have had to switch out to IBR. Lately, Pay and ICR have also reinstated their forgiveness attributes, so you can also do that. But if you're making a SAVE payment, you would not receive credit. You need to get out into one of the other ones, I believe. Okay, shall I go ahead and go through WRAP a little bit?
Go for it.
Okay, so repayment assistance plan. This is a new income-driven plan. It's not in place right now. We anticipate that it will be starting July 1 next summer. And it's basically simpler, but there is little flexibility. So you can see right here, I have a little chart that depending on your income, your payment would be a percentage of your adjusted gross income right off your tax return. And they're subtracting $50 per month per dependent child on someone's tax return. Interestingly enough, spouses and children outside the household do not count. Currently, they could count if they were a dependent. That what the definition of a dependent is, a little bit different than bankruptcy. It's basically if you're paying 50% or more of their support. It was kind of funny because there was a company in Florida, I don't know what company it was, but they were shut down by the Attorney General's office because they were telling folks, hey, you can declare someone a dependent if you buy them dinner, if you give them a ride. And if that was true, an Uber driver would have like 10,000 dependents, right? So that was not legal. And I don't know what the outcome was to any of the folks who followed that recommendation of that firm. But essentially, the real test is 50% or more of their expenses. Now, that's going to change because under RAP, they're looking at strictly on someone's tax return. And after July 1st, 2026, RAP will be the sole IDR option for a new loan. So basically, if you have an older loan, you still may be eligible for IBR, even pay, ICR. If you have a new loan, though, or if you consolidate your loans, which is essentially a new loan, after July 1 of 2026, you will only be entitled to RAP. Now, RAP isn't half bad. In many cases, the payment will be lower than what IBR is, but the payment term is 30 years. Under SAVE, it was going to be a bit shorter, 20 to 25 years. IBR, 25 years. You may still be eligible for public service loan forgiveness, which is 10 years. It's one of the reasons why you might want to think about joining PILS or something else. Public service is going to go through some changes, and we don't know exactly what to expect. So I'm not really focused on public service here because we don't know enough yet. I do think that the rulemaking that's going on now, that will be complete by July 1st, will give us some answers as to how the public service loan forgiveness program has changed. It's still going to be around, but what exactly we're going to see, we're not sure. We think there's going to be some litigation because I think certain things that a company or a nonprofit may do is going to exclude someone from public service, even though their job description might sound like public service. So we're going to have to wait and see on that. But with RAP, you're going to see the payment be much higher than someone who was making a SAVE payment. SAVE was in place for a few months. I don't know exactly how long until it was stayed. And now people have been on a zero payment on forbearance. But you can see there that if someone's making, say, $60,000 a year, under SAVE, their payment would have been just a tiny bit over 200, and it'll be 300 under RAP. And those changes were basically consistent with each level of income. If someone is on the IBR, though, you can see over on the right-hand side that in most cases, the payment is maybe a little bit less. The higher income, like if someone gets up to 100,000, and if they're married, maybe their payment might be a little bit more, 700 instead of 651. If they're single, I think it's cut off a little bit by our two pictures there. But you can see someone making 100,000, their payment was 880, single with one child under IBR, and it's 700 under RAP. So I think what I gleaned from this is that under RAP, you may be surprised in that someone's payment may be less than what IBR is, but folks are going to compare it to what they were told it was going to be under SAVE, and that's the problem. Because SAVE was only around for a short time until it was stayed, and now it's no longer going to exist. So people really need to compare what their payment would be under IBR and then what it would be under RAP. Now, before I get over to that slide here, just for a moment, we have been informed that pay and ICR forgiveness is back on the table. And so what pay is it's a 20-year plan. It's the only plan out there that really will allow someone to get forgiveness after 20 years. And so I would encourage you to think about pay. There are some restrictions as to the years of loans that are eligible for pay. You cannot have a loan balance. You cannot have a loan taken out before October 1st of 2007. And you have to have a direct loan taken out after October of 2011, I think it is. Studentaid.gov has all that information, so you can easily see if you're eligible for pay just by going on the government website. But if you're eligible for pay, it may entitle you to basically a 20-year term. So for someone who's a professional, we encourage that you might think about doing that. Now, the problem is this. All these other plans are going to go away. They're anticipated to go away in 2028. If that happens, then someone may have to switch to RAP at that point in time. We don't really know for certain whether or not someone will continue to be allowed to continue to remain in ICR and in pay after 2028. So that's a bit uncertain. We'll know shortly. But even so, if there's a new administration, we don't really know what's going to happen there either. But if someone can get forgiveness before 2028, then pay might be a good thing to do. Now, IDRs are only available for loans that are not in default. So if your client has already been delinquent for over 9 months, remember the loan's going to have defaulted. And so they're going to have to cure that default. I call them get out of jail cards. Just like Monopoly, you go around and you can consolidate a loan to cure a default. You can also rehabilitate a loan. So think about it. Rehabilitation is basically fixing an old loan. So it basically will remove all the late pay. So it's better for someone's credit to do a rehab. You have to make 9 out of 10 payments. They give you a payment based on income and so forth. And rehabilitation is something that if someone doesn't need to change the loan type, a lot of times it's better for someone's credit if they can afford how long it would take to do it, because it takes basically 9 months. It's the avenue of choice if you have a lot of income-driven credit, because with the consolidation, it's a brand new loan. It's paying off your old loans. It's not as good for your credit because the late pays are still on there, but someone's out of default, so they're not going to be reported through underwriting and things like that. But their prior IDR credit will be gone. There was a rule out there that it would be average. That's not in place. It's part of that save injunction. We don't think it's ever going to be, but we don't really know. Right now, I would assume it's gone. And so if you have a lot of IDR credit, don't think about consolidation. Think about a rehab instead. Now, if the loan is basically a new loan after July 1 of 2026, only wrap is available. If you consolidate loans, only wrap is available because that new loan is after July 1 of 2026 if you do a consolidation next fall or something. Importantly, one of the problems with public service over the past years has been family federal education loans, FFEL loans. You couldn't convert them to a direct loan without doing a consolidation. And if the consolidation was done before 2010, you had a lot of folks who basically had a FFEL consolidation instead of a direct consolidation, and they weren't eligible. So changing someone's loan type to a direct made them eligible for public service. We don't see that after 2010 because all loans after 2010 are direct loans. But if someone's loans are before 2010, they very well could be a FFEL loan, in which case you may want to think about doing a consolidation to change that loan type. And then you of course have to, for Parent Plus loans, you have to consolidate, have it done by July 1st in order to be eligible for IDR. And consolidation is faster. It takes 2 to 3 months versus a rehabilitation, which takes 9 months. So there's little quirks. If someone's in garnishment, they can't do a consolidation. They have to do a rehab. In the past, you'd only been allowed basically one rehab and one consolidation to a direct loan. If you already had a direct loan, you can't consolidate again because you already have a direct consolidation loan. If you have 2 direct loans, you could consolidate them together. That would be allowed. But if you had 2 direct consolidation loans, well, you could consolidate them together. But if you had a direct consolidation loan, you can't just consolidate it again. It's already kind of done. So it's a one-time thing. They're going to increase rehabs to 2 times. And so we anticipate going forward, there's going to be a lot more rehabs than consolidations, perhaps to leave all the options open, to have more income-driven credit, to have a better credit report. And maybe there's not that demand to change a loan type because we basically have had direct loans since 2010. So I think we're going to see more rehabs going forward than we have seen in the past, where we focus more on consolidations. This is a slide that talks a little bit about that Parent Plus loans, that you have to have the consolidation finalized by July 1 of next year in order to be eligible for an income-driven plan. Otherwise, someone's stuck with a larger payment not based on income. Now, this last part about you may need to enroll in ICR for 1 month, ask for a hardship forbearance if the payment is too high, and then when they auto transfer everyone to IBR, you'd be thrown in that batch. I would like for that not to happen. Currently, we're hearing that that is necessary. We're hopeful that someone who has a Parent Plus loan that has consolidated, they will automatically transfer to IBR and not have to do that 1 month enrollment. The 1 month enrollment, that's going to cause some confusion. There's quite a bit of people that are probably going to get lost in that process. So we hope that process won't exist, but currently it does. So if you have anyone who has a Parent Plus loan, the best option right now is to do a consolidation and then apply for an economic hardship. and ICR. Basically ICR so that a payment can be made and they see what the payment is, economic hardship if they can't make that payment, and then automatically transfer into IBR. The total and permanent disability discharge is a program that we see a lot and we like. It's restarted. And so don't forget about it, because the servicers don't spend a lot of time talking about it. But if you have someone who's not working or they're getting close to retirement, they have health issues, maybe a TPD, total and permanent disability discharge, is the out for them. We do a lot of those, and frankly, they're wonderful. There is no 3-year post-discharge income monitoring. So if someone has real estate, some kind of investment, that doesn't matter any longer with what their income is afterwards. The physician certification has been expanded. We have always used a physician that is basically very probably overqualified to do these. And the approval is very fast, not as much anymore. It's taking more like 6 months than 90 days, but we're still getting excellent results with the total and permanent disability discharge. We do have a little bit more clarification with taxes. I'm kind of going through this a little faster because I want to get to the bankruptcy portion. We now have heard that if you have the forgiveness, as long as it was basically something that you're entitled to before December 31, even though the paperwork isn't being processed until 2026, you will get the forgiveness. And that's offered by the Americans Rescue Plan that was part of the COVID stimulus. So bankruptcy, why are student loans being impacted with the bankruptcy now? So this date is very important, November 17, 2022. That was a date that basically some new process came into play with bankruptcies, and it's called an attestation process. It enables someone to file an adversary proceeding and then submit a rather lengthy, basically application saying, here's all the things I've done, here's why I have a hardship and I cannot repay this loan. And it's a wonderful program because it doesn't go through the regular court processes that you would have with an adversary proceeding. You can ask for everything to be stayed. That would be depositions. That might be, whatever discovery out there, all of it stayed. And you instead submit this attestation form. I can't say that right. And it's reviewed by the Department of Ed and the Department of Justice, and they come back with an answer. And the court doesn't necessarily have to agree, but they typically don't disagree. So to tell you the importance of this program, here's an example. This is one that we had complete 3 weeks ago. Professional borrower, they made $4,000 a month. They were relatively young. They had nearly $400,000 of federal student loans. Now, normally, the Department of Ed would respond, well, if you're not making good enough income, you can do an income-driven plan, your payment will be low enough, blah, 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 you don't have an undue hardship. We filed an adversary proceeding. We submitted the attestation form. We waited a long time, took longer than we thought. But at the end, we have a signed stipulation. We have a court order. That's important because today you don't have a very certain avenue of relief sometimes with respect to the politicalization of student loans. So having a court order as to what's due and the amount that's been discharged is fantastic. The discharge debt is not taxable. So in this case, we had agreed on a resolution, which is a 95% reduction of $380,000. This client now owes a little over $15,000. The payment is $100 a month. And all that debt that was discharged or will be discharged is not taxable. And you can look at the case, the adversary case there is Larkham versus U.S. Department of Education, if you want to see some of the documents that were filed and things like that. But this is the kind of outcome that you can get with an attestation case in bankruptcy. So don't think it's nothing. We just received this, like I said, 2-3 weeks ago or so. It took a long time to get. These cases are averaging a year in duration. I don't know if that's going to be shortened at some point or another, but right now it's been about a year. This program is a policy change. It's not a law. It's not even an amendment to a statute or rule. But the program was initiated during President Trump's first term. And so it's basically guidelines that the Department of Ed and Department of Justice use to interpret what is an undue hardship. And one of the nice things is that you have a presumption. You have many presumptions that are applied that normally were not previously applied. So in other words, if you have someone that is 65 years of age or older, if they have a disability or injury that impacts their income potential. So let's say that they do have some income and they're able to work, so you can't get a physician certification that they're disabled. Maybe you want to try bankruptcy attestation instead because it affects their income potential. Maybe they're unemployed for 5 of the last 10 years. Maybe they didn't get a degree. These are all listed in the guidance as to reasons for a presumption of discharge. Now, they can all be opposed by the Department of Ed. It is encouraged that you have at least a 10-year repayment period, and that can include forbearances and deferments, but you need to have the loans in existence for a 10-year repayment period at least before you really try this. You also need to have the loans be a direct loan. The guidance is not applicable to non-direct loans, to FEL loans, for instance. And so it's very important that before bankruptcy is filed, maybe you think about, well, should that client consolidate their loans to make them a direct loan if they have a FEL loan so that they're eligible for the attestation process? You can use the attestation adversary anytime during the case. What we typically do is if we have a Chapter 13, we typically wait till the last year of the plan. The reason for that is because we're ensured that the plan is going to be successful. So we're going to have an outcome that our client can live with. We also want to make sure it's a ripe issue with the 11th Circuit case law. If it's not ripe, they will not hear that. We can do it earlier in a Chapter 7, but in Chapter 13, we tend to wait till later in the case. Now, the attestation has a lot of confidential information. You do not file it. You actually just send it to the AUSA. And the recent Stretto, they did a seminar recently, but Stretto has a lot of the forms and things right online. Their fees are relatively small to go ahead and do some of the transfer of information as well as obtain some of the information that you need. I think it's important to have a retainer agreement that allows you an out. So in your retainer agreement, if, for instance, the Department of Ed says that your client is not entitled to any kind of discharge, whether it's whether it's partial or complete discharge, that you then have a way out of the case or the application of additional attorney's fees. We have a certain fee. I won't actually say it on here due to antitrust rules and so forth, but we have a certain fee that we would charge for an attestation process, and then we have a different fee that we would charge if it were to go beyond that. The Department of Ed wants to get paid on these loans, so we're not seeing denials, we're just seeing extensions. So it is important to file on good facts. We're looking for a loan that's at least 10 years old, and we're looking for a sad story. We're looking for a lot of history there. Things that the client has done before to try to address their loans. Have they communicated with their servicer? Have they tried forbearances, deferments, repayment plans? What have they done? Have they rehabilitated or consolidated their loans? If they've done nothing but ignore everything, that counts against them. So the history is important, and we may do some of that stuff before. You still have to file an adversary complaint. You still have litigation, but you can stay most of the things. And then at the conclusion, you can either say, okay, if the loan is not discharged, maybe there's an administrative, if the loan is not discharged, maybe it's a voluntary dismissal or an additional fee that would come into play. And then we also use adversary proceedings for private loans to show either undue hardship. Maybe it's a non-qualified education loan. In other words, too much was lent out. Maybe it was to a non-dependent borrower, to a vocational school, to a non-Title IV school, you name it. And so there's a lot of things you can do with private student loans in bankruptcy to discharge them in an adversary process. A couple cases that I think you might want to take a look at is the Hamilton case and also the Woodard case. Both of them describe the process a little bit. At the very bottom here, you have a site, use the data under Hamilton. That is a site that you can go and see what the cost of education is for a particular school. But you may find that a lot of your clients have taken out loans that were tuition answer loans, or that were used to pay off a car, pay someone else's debt or something. And it was beyond the cost of attendance. And so those may be dischargeable. Just frankly, an undue hardship, though. Most folks seeing you will have some kind of hardship there. And so we're alleging that. There's additional tools to reduce student loan in bankruptcy, not just adversary process. So you have the ability to file an adversary against your federal loans with that new attestation process. You have the ability to file an adversary against private loans, arguing that they are either non-qualified educational loans or they're an undue hardship. You can ask for mediation, try to settle them. A lot of the settlement plans are using drastically reduced interest, 1 or 2%, as opposed to 10 to 15%, maybe a percentage of the loan instead of the full loan. And your payment might be very, very low for a 20-year term instead of very, very high for a 5-year term. So we're seeing a lot of really good settlements that work for our clients in a private student loan adversary case. But there's things you can do that are beyond adversaries. That bankruptcy IDR that is currently stayed, if that comes into effect, that's going to be really, really nice because it will allow someone to make a student loan payment based on taking into account very high medicals or child care or house payment or whatever it is that we can't do outside of bankruptcy. Remember, there's no statute of limitations on federal loans, but there is on private loans. So a lot of times we can challenge a private student loan through a proof of claim in a Chapter 13. We can challenge the amount due, the statute of limitations issue, whether it's a qualified education loan, who owns it, anything. And then in a Chapter 13, an automatic stay does protect the co-borrower. Frequently, we are having to, if we do an adversary case, we have a settlement with the borrower. We, in many cases, can join the co-borrower and have the protections of that as well. Sometimes we can't. We do a separate settlement with the co-borrower after the litigation in the adversary in the bankruptcy. One of the key provisions that we've used over the past few years has been this tax-free settlement of a private student loan. As long as the last payment was paid and received before the end of this year, that forgiveness would be tax-free. That's going away. And so I imagine that in the future, that's going to be a little harder to find a good settlement number because someone may get an IRS bill instead. I think that will encourage an adversary proceeding in bankruptcy, perhaps, because if the debt is discharged in bankruptcy, it is not taxed. The settlement there for non-qualified educational loans, again, we're seeing a reduction of balances, very low interest rates. We may have a payment over 20 years. And that payment may be $100 versus $700. And that's what our client needs. They can pay a little bit back for the loan, but they can't pay the massive amounts back that they're receiving bills for. And then we're always trying to use these consumer laws whenever we can. FDCPA, if your state has we have here in Florida, Florida Consumer Collection Practices Act. Your state may have something similar. We use inaccurate reporting of settlements and things on credit reports. So we use the FCR a bunch. And then you can trigger disputes by using different letters and things and cease and desist. So all those consumer statutes may play a role. We're not utilizing usually attorney generals or the CFPB, but we're utilizing litigation under these state, basically, laws or federal laws. And so it's a little harder right now. We are seeing not easy answers. In the last few years, we've basically seen some early answers to there's not a payment due. We have SAVE out there. We have the IDR audit. There were some other things as well. But we still have quite a lot. The TPD is moving forward very nicely. We have the bankruptcy IDR that's stayed but hasn't been thrown out and I think may very well persist. The attestation is working wonders. We're seeing some really good avenues in bankruptcy that are opening up for student loan debt relief, whether it be federal or private. So don't ignore the options that are out there for potentially filing a bankruptcy. And with the Trump administration, you have a guardrail. Basically, you have a penalty. Someone has to file bankruptcy in order to get the relief that is offered under these programs. That's good. That's a sign that even though the attestation process is not a law, that it likely will continue to exist because it's a guardrail. It's a way for someone to get relief, but yet they have a penalty for doing so, which is filing bankruptcy. Maybe that's not much of a penalty. Maybe it is, but it seems to be working fairly well. Now, it's important that your court has a process that allows you to address student loans in bankruptcy. Here in the Middle District, we have something called the Student Loan Management Program. And it was put into effect shortly before the COVID pause. So it wasn't used a lot because the COVID pause and what happened after gave us a lot of avenues that we didn't really need the Middle District program anymore. But now we're going to need it because if you have someone who files a bankruptcy, what the Department of Ed typically will do is they will place the loan in forbearance. And we used to argue that is a false start as opposed to a fresh start, because when they get out of bankruptcy, maybe they fix the car, maybe they fix the credit cards in the house, but now they have this larger student loan. And so with a program, with a court program, and there's 5 courts that have adopted the Middle District provisions. You can easily see them. Go to the Tampa Bay or Middle District of Florida's court site, and you'll see that if someone applies for that program, then they can apply for an IDR instead of having a loan placed in forbearance. And then these adversary proceedings, of course, can take place. But you don't, the last thing you want is to file a bankruptcy and then just do nothing with student loans, because what you'll have is the loan will be placed in forbearance. The client at the very end won't know really what happened with their loan. And now they're going to owe more than they owed before they filed a bankruptcy. So it's important to address the student loan in bankruptcy. It allows them for tax-free relief and a little bit more certainty than perhaps they would have elsewhere. And they really don't have to do much. There's no contacting the servicer. As an attorney in bankruptcy, you're pretty much doing it for them. And a portal through a court program is kind of nice for that. There is some different resources available. We have our website. The Ombudsman Office is kind of, I don't know if it's really closed, but it's not really working for us right now. We don't know what to anticipate there in the future. There are some different assistance through student loan borrower assistance. NCLC manuals are fantastic. They have a student loan treatise that's really, really quite good. But there is information. And then we always use the studentaid.gov, which is the government website. Now, it's important that you don't use your client's information to go online, their FSA information. That is a felony. You need to make sure that your client logs on, pulls the data for you to look at, for you to review. You don't go on and get it. They send it to you. So we have some instructions and screenshots that we send our clients to get us the information that we need. Here's our contact information. If anybody wants to reach out to us, you're more than welcome. That student loan shouldn't be a life sentence. I actually took that from a Kansas judge who had done a discharge case. And they were, that was a quote out of the case, because the judge felt that those student loans really shouldn't be a life sentence. And I always liked it. So we kind of adopted it for a few different things. I think we might have some questions. I see a bunch of things in the chat here. Jorge, do you know if we have any?
Yeah, we do have a few comments. I've been dropping some of these resources into the chat as well. I actually found an article that you wrote, Christy, from back in 2019 related to the program in the Middle District Court. So I dropped it
Oh,
into
yeah.
the chat. I'll make sure to include it in the materials as well. So we actually had a comment really early on, and which is, I guess, kind of the point of this webinar. It's under the Q&A, and it was posted by an anonymous attendee, and it was after not receiving any positive answers from loan servicer
Wait,
nor
I'm
Fed
sorry.
Student Loans website.
A
I
motorcycle just went
consolidated
by.
and
So I
now
missed
find
all that.
myself, yeah, from $300 down to $40. It was $40. Now it's up to $300.
If there was a question in there, can you repeat the last couple of sentences? A motorcycle went by and I missed all of that.
Sorry, so I'm gonna read. It was more of a comment, if you want to kind of talk about it, but this was really early on during the presentation, so that's why I held off. But it was after not receiving any positive answers from loan servicers nor Fed Student Loans website, I consolidated and now find myself having to make $300 monthly payments, where in the past I was paying about $40 a month, and it's still so hard to communicate with people answering lines or trying to find help.
Okay. Yeah, it is hard to find good communications with someone's servicer right now. We just have to be patient, and I encourage multiple attempts to try to figure out what's going on. As for why someone's payment went up, maybe the income went up at the same time. The income-driven plan payments should be the same from a few years ago. There's only that aberration of SAVE that, again, existed for really just about a year, and then it was stayed to where someone didn't have a payment. But before SAVE was put into existence, really IBR was the lowest payment out there. And someone can file a separate tax return to have it based on only their income. Maybe that was a change, and maybe a joint tax return was filed. You're always welcome to reach out to us, see if there's anything that can be done to lower your payment and see what's going on.
There was another comment early on when you had the slides with the stats, and I believe it said 42 million Americans with student
Mhm.
debt, and there was a comment that that number appears to be in par with SNAP. It's just a coincidence, with people right now, with the government
Oh,
shut down and
interesting.
SNAP. It seems 42 million seems to be on par. There was an observation. So there was a save question that you answered earlier. I don't see any other questions yet. So if anybody wants to raise their hand and ask a question, I can bring you off mute. In the meantime, I'm going to drop the CLE code into the chat. I'm going to read it out loud for the benefit of everyone. So the CLE code is 2515247N as in Nancy. So that's dropped into the chat. Let's see if we have any other questions. I don't see any in the Q&A. I know we're right at time, so I wanted to take this opportunity, Christy, to thank you for joining us again. And we're really lucky to have you leading these webinars because student loans is not an easy topic. Thank you for sharing all these other alternatives, not only bankruptcy, but other ways to deal with higher payments and defaults. And thank you everybody that joined us here today. So we're gonna
Good
have
luck,
to keep
everyone.
an eye out on everything that's happening. So Chrissy, any final words before we wrap up?
No, just like I said, avoid default if you can. There's really no point in it, and it's best to take advantage of the bankruptcy attestation and income-driven plan. Don't think that badly of WRAP, even though it's 30 years, the payment actually may be less, and it doesn't have the interest accrual that has been such a problem with some of the other plans. So, WRAP is not bad, actually. It doesn't go into effect till July 1. That's important to know, too. I hope this has been helpful.
Well, it's
And,
very
and
helpful.
I
Thank you again, Christy.
And I think once we know more, we'll set up something else with more public service information. Right now, it's too fuzzy to really do that, but it hasn't gone away, but it may be a little different than what it looks like right now.
All right. Well, thank you again, Christy, and everybody have a great rest of your day. Bye.
Thank you. You too. All right, bye-bye.